All right. Good evening, ladies and gentlemen. My name is Barrister Austin Aripo Abam, and I'm elated and delighted to take you on the series this evening. I'll be talking about how to move emotion in the court of law. In the court of law. And the question that beats your imagination now, or that should be begging for answer in your heart right now, your mind right now, would be, what is emotion? What is emotion? Of course, emotion is an application, is a formal application, is a legal way of writing an application before the court, presenting your request before the court, what you want the court to do for you. All right. So we call it emotion in our legal parlance. Now, it could either be interim or interlocutory. Emotion is interim when it has to do with the beginning, the commencement of a matter. Let's say the matter has just been filed and you want something urgently. You want the court to grant you an urgent relief. At the beginning of the proceedings, you bring a motion ex parte. Motion ex parte, that is, the court will hear only you, will hear just one side. All right. And that is what we call interim. Interim most times it's an injunction. Most times it's an interim injunction. It comes by way of an injunction, restraining someone from doing something, right? So you either bring a motion ex parte or you bring a motion of notice. A motion of notice is that you're notifying the other party. You are not taking the other party by surprise. And most times, motion of notice usually comes by way of interlocutory. It's always an interlocutory application. Interlocutory application. An application that is brought in the course of proceedings. In the course of proceedings. Right? So tonight, our major interest is how to move a motion before the court. Right? So how do you move a motion before the court? Look at the motion here. The content of the motion, of course, we see the motion is headed in the court. The motion has a designation of parties, has a motion number. It has a title, motion of notice. Of course, it also has an introductory part. Then it has the relief part, where you state your prayers, what you want the court to do for you. The motion is supported by a written and an affidavit in support of it. That is the evidence where you state your grounds and reasons why you're asking the prayers. And of course, it has, if you have annexures, that is, you have exhibits you can annex to the motion to buttress your point, and also it's supported by a written address. So the rules of every court stipulates that a motion should be supported by an affidavit and a written address. Gentlemen, let me quickly move the motion practically. Right now, this is a template of a motion paper. This is a motion paper. You come, you start. Of course, when the court wants to hear you, the court will first, after they've called the case, you announce your appearance as a lawyer or counsel before the court. For example, may it please this honorable court, A. Abam Esquire, I humbly appear for the claimant applicant or the defendant applicant, as the case may be. Right? So you say, before my lord, you introduce your motion. Before my lord is motion number M slash 2806 slash 2024. My lord, the same motion has been served on the other party, because the motion of notice has been served on the other party, on the respondent, and the respondent has also responded accordingly. The court will now give you leave to move the motion. This is how you do it. Before my lord is motion number M slash 2806 slash 2024. My lord is a motion on notice brought pursuant to Order 43, Rules 1 and 2, Order 25, Rules 1, 2, and 3 of the High Court of the Federal Capital Territory, Abuja Civil Procedure Rules 2018, and under the inherent jurisdiction of this Honorable Court. My lord, this motion praises Honorable Court for the following reliefs. Number one, an order amending the defendant's joint statement of defense and counterclaim in the manner highlighted in the proposed amended statement of defense and counterclaim annexed here too. Relief 2, my lord, leave of court to file additional witness statement of oath pursuant to the amendment of the statement of defense. Relief 3, my lord, an order deeming the amended statement of defense, counterclaim, An additional witness statement on oath filed as separate process as duly filed and served. Appropriate filing fees haven't been paid. Then number 4, the last relief. My Lord, and for such further or other orders as this honorable court may deem fit to make in the circumstances of this case. All right. Then the motion is dated. Of course, it is dated. Now, for a senior counsel, this is for a junior counsel. For a senior counsel, you don't need to read out the reliefs. Most times you just say, my Lord, the motion praises honorable court for the following reliefs. 3 principal reliefs, my Lord, and 1 omnibus relief. The omnibus relief is a general prayer. So the motion praises the court for 3 principal reliefs. My Lord, the reliefs are contained on the face of the motion paper. I pray that my Lord deem the prayers or the reliefs as read. My Lord, the motion is dated the 16th day of January 2024 and filed on the 19th day of January 2024. My Lord, the motion is supported by a 7-paragraph affidavit deposed by one Janet Chinasa, a litigation secretary in the law firm of SM Mosu and Co. Guardian Chambers. My Lord, we place reliance on all the paragraphs of this affidavit, especially paragraph 4, sub C. My Lord, annexed to this application or to this affidavit is Exhibit A, the proposed statement of defense, proposed amended statement of defense and counterclaim. My Lord, we seek the leave of court to place reliance on all the paragraphs of the affidavit, and if the leave is so granted, we place reliance on all the paragraphs. My Lord, in compliance with the rules of this honorable court, we also file a written address. My Lord, we respectfully adopt the written address as our oral argument or oral submission in support of this application. And on the whole, respectfully urge my Lord to grant this application as prayed. As prayed. May it please us, honorable court. Okay, so you have moved your motion. This is how to move a motion. Then if you are done moving the motion, if there is time and you want to shed light, you want to shed more light, you want to straighten some creases, you want to straighten some creases, you want to explain, we call it adumbration, you want to adumbrate. The court can give you a few minutes to adumbrate, shed more light on the facts, and also shed more light on the law. So you can say, for example, my Lord, we submit in favor of the applicant that the applicant has made out a case as per the affidavit evidence before the court that will warrant this court to exercise its discretion in favor of the applicant. Say, my Lord, for a party amendment, it is tried, the law is tried, that a party in proceedings, in legal proceedings, can be allowed to amend his pleadings at any stage of the proceedings before judgment is delivered. My Lord, of course, the essence of amendment is to streamline evidence, to streamline facts, and also help place all material facts before the court that will aid the adjudication or the effectual determination of the suit before this honorable court. My Lord, that the applicant has done. That the applicant has done. We submit, my Lord, that this honorable court will exercise its discretion in favor of the applicant. May it please, my Lord. All right. Thank you so much, gentlemen. Please, I will implore all the new weeks and every other person, both senior and juniors, and every other person that has interest in law, legal aspirants out there that will have interest in law, to please subscribe to my YouTube channel to learn more about the law and also learn more about your fundamental rights. Thank you. Have a blessed weekend.